The law of tort. Breach of duty in negligence liability. In negligence claims, once the claimant has established the defendant owes them a duty of care, they must then prove that they are in breach of duty. Whereas duty of care looks to the situation and circumstances, breach of duty focuses on the conduct of the defendant. For example, in the situation of road use, a car driver owes a duty of care to other road users. The driver's conduct of failing to pay attention or speeding relates to the breach of duty. The principles are set out in common law. Breach of duty in negligence liability may be found to exist where the defendant fails to meet the standard of care required by law. Breach of duty is decided by the objective test. This means the defendant is expected to meet the standard of a reasonable person in the same circumstances. The objective test was established by Vaughan v. Menlove, where the defendant's judgment of whether the haystack would catch fire was not sufficient. It was obvious to a reasonable person. The objective test can be variable and may depend on the circumstances of the particular defendant or the situation. For example, in Condon v. Bassi, it was held that an amateur footballer is not expected to meet the standard of a footballer in the first division. In the context of horseplay, there is a breach of duty of care only where the defendant's conduct amounts to recklessness or a very high degree of carelessness. This position of the law was set out in Blake v. Galloway. If the defendant is a professional, they will be held to the standard of a reasonable person within that profession. This applies also to trainees. In Wilshire v. Essex, a junior doctor was required to meet the standard of a qualified doctor. No account can be taken of their lack of experience. Similarly, a learner driver is expected to meet the same standard as a reasonable competent qualified driver according to Nettleship v. Weston. Whilst this may seem harsh on trainees and learners, if they were not held to this standard, the injured party would be denied compensation. The Bolam test applies where there is divided opinion within a profession as to the appropriate course of action in a particular situation. Under this test, a defendant is not to be treated as in breach of duty by following one line of opinion rather than the other. This comes from the case of Bolam v. Friern Hospital. In Bolitho v. City and Hackney Health Authority, it was stated that for the Bolam test to apply, the opinion must be defensible and rooted in logic. In Mullen v. Richards, it was held that a child is not expected to meet the standard of a reasonable adult, but will be judged by the standard of a reasonable child of the same age. The courts have not taken a consistent approach in relation to where the defendant's conduct is affected by illness. In Roberts v. Ramsbottom, there was a breach of duty when the defendant had a stroke whilst driving. He had to meet the standard of a reasonable competent driver with no account taken of his illness. However, in Mansfield v. Weetabix, the defendant was not in breach of duty as he was held to the standard of a reasonable driver who was unaware that he was suffering from a condition that affected his ability to drive. The inconsistency in approach is often explained on policy grounds, in that Roberts concerned personal injury sustained by a pedestrian and thus a breach of duty was found in order to ensure the victim was compensated. Whereas, Mansfield involved property damage which would have been covered by insurance. In applying the objective test, the courts weigh up certain risk factors. The courts use these risk factors to determine if the defendant has acted reasonably. If they are deemed to have acted reasonably, they are not in breach of duty and not liable to pay compensation. One factor the courts consider is the likelihood of harm. The defendant is not expected to guard against events which cannot be foreseen. In Roe v. Minister of Health, the defendant was not liable as the minuscule cracks in the ampoules for storing the anesthesia were not visible to the naked eye and so the risk could not be foreseen. In Bolton v. Stone, the cricket club were not liable as it was unlikely that a ball would be hit out of the ground. Evidence was produced that it had only occurred on 6 occasions in 30 years. In Haley v. London Electricity Board, the court rejected the argument it was not foreseeable a blind person would be walking unaccompanied as the defendant hadn't even done enough to safeguard the risks to a sighted person. A further factor the courts weigh up is the seriousness of potential harm. In the Wagon Mound No. 2, the seriousness of harm was so great, it mattered not that the likelihood of harm was so low. The oil leak would have cost nothing to prevent. It was simply closing a valve. So, in weighing all the risk factors, the court held there was a breach of duty. Paris v. Stepney established that the vulnerability of the claimant will be taken into account. The claimant only had sight in one eye, so the seriousness of harm to him was much greater. The employer should have provided safety goggles and were in breach of duty for not doing so. The courts also consider the cost of prevention. In Latimer v. AEC, it was held that there was no obligation to close the factory. The defendant was only required to do what was reasonable in the circumstances, not go to every length and expense to prevent it. By putting up warning signs and putting down sawdust, they had acted reasonably. The court will also consider the social utility of the defendant's conduct. That is how useful their action is to the community. For example, in Bolton v. Stone, it was considered providing a cricket ground was beneficial to the community. In Watt v. Hertfordshire, the emergency of saving life outweighed all the other factors. In summary, once it has been established that a duty of care arises, the claimant must show the defendant was in breach of duty. This means they have fallen below the standard of a reasonable person in the same situation. This varies for children and experts, but not trainees or learners. The courts have been inconsistent with regards to illness. The courts weigh up the risk factors in deciding if the defendant has acted reasonably. These include likelihood of harm, cost of prevention, seriousness of harm, and the utility of the defendant's conduct. This video is part of a series of videos on tort law from www.e-lawresources.co.uk. Please subscribe to our YouTube channel. It's free to do so and will help us to keep providing these videos. Check out our website, which provides lecture outlines and case summaries. See also www.e-lawrevision.org.uk for revision games and quizzes. Thanks for watching.